I'm not ready to go yet, okay? I'm not ready. You gotta wait. I got shit to do. I'm in the middle of something, all right? Just hold on.
Watch your mouth or don't come in here.
Uh-oh.
Oh, yeah, people, come on, we're adults here. You know what? What is the point?
Yeah, we're adults here. I got a fucking Burger King fucking thing on my head. We're all fucking adults here, guys. People in my chat, 2 words. What are they? 2 words. Let me see the chat flood. Let me see the chat flood. 2 words. Okay, next caller. Please. Let's get into the meat and potatoes, which translate in American to dick and balls.
I got flip-flops. These are my flip-flops. Yeah, I really like my flip-flops because I can put them on. Because look, watch me put them on. I can put them on all by myself. Watch me put them on. Look, are you watching? Look, these are my flip-flops.
Thanksgiving Day. I remember it clearly. It was Thanksgiving Day. I was inserting myself in somebody else's fucking business as a cash grab, and you know.
This channel is harsh reality.
Karen Yak se jodió la sucia vida. Amen.
This is Jonathan Lee Riches. I have cheeseburgers. I'm gonna put cheese on them. I'm gonna make sure that I have my hamburgers because I'm a big boy now and I can make the hamburgers. My mom lets me use the stove now.
And I'm just like, wow, I like receipts, and they brought receipts. Like they had evidence to back up everything they said. And I'm like, okay, well, there's got to be another side to this, right? Like, this can't, no, this is too fantastic.
Yeah, because you're not going to just jump to the conclusion that there's a conspiracy amongst cops to cover up a murder. You know what I mean?
Yeah, I mean, cops and just like soccer moms and shit. Like, that's what made it even crazier. Like,
yeah, get it, Betty. Yeah,
did you have a close relationship with your mom?
Get it, Betty.
Oh, of course, I still do.
Yeah.
My older sister was kind of sad. She was more of the prissy girl that like going
that is
and
the best shit fucking
shopping
ever.
for the dresses with mommy. I was the tomboy that liked playing with the feet.
Shout out to Cherry for just being just easily the most faithful and loyal supporter that I've ever had. That someone could have that tenacity with loyalty. And I'm really blessed to have someone like Cherry be part of this channel and in my life. So it means a lot. And yes, I named him after Mr. T and Rocky. Say, woman. Say, woman. Say, woman. Since your old man ain't got no heart, why don't you come down to my apartment tonight and I'll show you a real man. Oh my God, I'm so in love with this little dude. Yeah, I'm gonna go ahead and wrap this one up. I love you guys very, 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 very much. And we will do this again very soon, my friends. Oh, say bye. Say bye. Oh, I love you too. Give me a kiss. Oh, I love you. Bye, guys.
Karen left the
Woo! Good afternoon, people. Oh my goodness. Oh my goodness. Man, that justice, man. It's you smell it? It's getting pungent. People, I love you guys so much. I'm so glad you're here. I was just in Attorney Melanie Little's chat there for a little bit there. Very interesting stuff. I have all the stuff that she has, and I'm not going to be able to explain it to you half as well as she could. But we're gonna go over some of it, and we may have a surprise guest drop in and say hello, but I don't have confirmation on that yet. So I don't know if that's going to be a thing. But it would be cool if it does happen. Yeah, I've got a lot of stuff here. Thanks to Cherry, of course. And oh wait, Liz became a new member. Welcome to Logic. Good to have you. Now, there's a lot of people who I gotta tell you guys real quick. I gotta touch on this real quick. They're like day before yesterday, I had someone in the chat gift over 40 memberships. Gift 40 memberships, and those of you who are gifted memberships, you still get the very few perks that I offer for members only. And one of those is that you have access to my Discord. So if you have a membership and you enjoy interacting with this chat, those with green handles in the chat have access. And so what you have to do is you have to email Cherry, I think, with your proof of membership. Cherry will drop the requirements in the chat here. But you you can interact with the chat beyond the live streams if you'd like to, which means that you don't have to catch replays, or when you do catch replays, you are going to have to catch replays, but if you miss the live. But if you happen to catch a replay, that means that you don't have to flood my comment section with comment after comment because you think that it's still live when it's not. So don't do that, please. I mean, you're free to do it. Just please don't. But you can absolutely interact with everyone in the chat who has a green handle in the chat. So beyond, and sometimes I interact, sometimes I don't. Cherry is more or less pretty active in there as well. But it seems to be a nice place where people can interact with each other and enjoy each other's virtual company beyond this here. So yeah, I realize, like I said, a lot of new members, and a lot of new members don't know that they can do that. So now you know. So again, just email Cherry with your proof of membership, I guess, and she will send you an invite to the Discord. If you don't have Discord, you can download the app. It's free, and you can download the app, accept the invitation, and voila, you are in the Glarer universe outside of here. So yeah. I hope I explained that well, because I don't explain anything very well. So yeah. Yeah, Jen's tooth, pretty crazy. Yeah. So when that happens, you know, shut up, Jerry. When that happens, yeah, the Glaraverse, right? When that happens, you know, I never know how much you guys know and how much information I can provide that's useful to you. So yeah, I'm terrible at running a channel. So yeah. Anyway, and thank you guys all for those of you who are here from Melanie Little's chat. I'm really grateful that you guys are here. I look forward to the next time I get to speak and hang out with her. I think the next time that's going to happen is going to be here, I think, maybe, I don't know. We'll see. Hopefully. And I know that she had the great Mark Betterow on with her earlier, and I think Mark Betterow is going to be on the Young Jerks at 6:30. And so if you want a better explanation of these things, well, I don't know. I mean, Betterow's he's gonna give his opinions, but I don't know if they're gonna like meticulously go over these filings the way that Melanie Little did, but you'll at least get his understanding of them, I'm sure. So I look forward to that. Joseph Kane gifted 5 memberships. Wow, thank you, Joseph Kane. Appreciate you, buddy. You are fantastic. All right. Congrats to all you guys who just got memberships. Right on. So I don't even know which one I'm gonna pull up to go over next or first. Let me take a look at what I got here. I know I definitely want to go over that motion for sidebar. And I definitely want to go over some of these exhibits. Let's just go over, let's see what this is real quick first. Okay. Sorry, I'm just getting an idea of what I'm looking at here. Okay, so this is just the docket. Let's take a look at that real quick because I'm curious just to see what's on this thing. So let's see. Yeah, there's a lot. I'm not going to go over all of it. That's for sure. But I haven't looked over this stuff yet. And you guys know I like to do this stuff live. I got a little taste of what it was from Melanie Little's live stream. But again, I'm not sure exactly what it was that she went over exactly. Okay. Oh, wow. Okay. Yeah, I don't want to go over that. Hold on. Okay. All right. Yeah, basically. Yeah, that's not something that I want to show on the screen. So we'll take a look at something else here. All right, let's just read this. See where we're at. Okay. This is the petition for relief. Now, I don't know this Michael Pabian dude. I don't know if you guys can hear my stomach growling. It's so bad. I'm just going to go ahead and read it. Now comes the defendant, Karen Reed, who is aggrieved by an August 23rd, 2024 memorandum of decision and order. Now, before I continue this, disclaimer, there's going to be a lot of legal jargon here that I'm not familiar with. My vocabulary is not that broad, so I do apologize in advance if I get stuck on a word that I've never heard before. Memorandum of decision and order denying her motion to dismiss on double jeopardy grounds in Commonwealth versus Karen Reed. Now, for those of you who don't really know exactly why I'm going over this, what I'm going over here, and Mike B from 413, he works for Weinberg. Thank you. Okay, appreciate it. Member for 8 months, right on. Okay, that answers my question that he works for Weinberg. Great, awesome, thank you. For those of you who don't know exactly what I'm going over here, why I'm going over it, so Karen Reed, she was on trial for murder. When the trial was over, the judge, Beverly Cannoni, she declared a mistrial after the jury expressed to her that they were, or at least the foreman expressed to her that they were at an impasse and that they could not reach a verdict. And without giving them instructions, although there were 3 different charges, without giving them instructions to go over each charge and explain exactly which charges they were stuck on, she just called a mistrial. And for months, I have been saying that this can't be the way you're supposed to do things. And the fact of the matter is that she's the one who made the mistake, not anyone else, in my opinion. The lawyers that I hear talking about this seem to agree. So times like these, welcome to Logic. Thank you so much. Appreciate you. So she calls a mistrial, and which means that since the first charge was second-degree murder, that means that she's going to be retried for second-degree murder. But here's the snag. The snag is that after this mistrial was called, apparently, according to certain jurors, who have come forward, a couple of jurors came forward. One of them was stating that on the bus ride home, something didn't feel right. They were like, wait a second, what's going on? And then a couple of them, unsolicited, mind you, under their own free will, chose to reach out unsolicited, reached out to Karen Reed's defense team and the Commonwealth of Massachusetts, meaning the prosecution, meaning Michael Morrissey's district attorney's office. And so they reached out to let them know that they reached a unanimous not guilty verdict on counts 1 and 3. And count 2, they were at the impasse on. So what they end up doing is the defense files an appeal, or the defense doesn't file an appeal. They file a motion to dismiss. Excuse me. They filed a motion to dismiss. Mr. Weinberg, who's been brought on as an expert brought onto the team as an expert, I believe his field of expertise in law, I believe, is appellate court. Because I mean, I think it's safe to say that they anticipated filing a motion and it being denied, and then them having to appeal it. This is the appeal. So, Weinberg's argument, which is the same argument that everybody here with common sense were saying before he sat up there in that motions hearing, he says, well, the constitutional thing to do here is to question the jurors. That's all you have to do. The opposition motion that the Commonwealth files states that, oh well, this is unconstitutional and you can't question the jury about what happened in the deliberation room, blah 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 blah, right? But the problem with all that is again, that is an example of look over here, don't look over here. An absolute example of Lally's poor attempt at misdirection. Now, the whole thing is it's not designed to fool Auntie Bev, because Auntie Bev, she's not stupid. She knows what she's doing. And she gets to say that, oh, well, I misunderstood, blah, blah, blah. At least I'm just speculating. But what I'm getting at is this the defense, we're not requesting that they discuss what happened in the deliberation room, what happened during deliberations, why they reached the verdicts that each juror reached. We're not trying to get to that. We just want them to be asked a simple question. Did you vote guilty on this charge? Not guilty. Guilty or not guilty on this charge, and this charge. That's all we're asking. That's all the defense asked. That's all Mr. Weinberg asked during that motions hearing. So I don't understand exactly what the big to-do here is. This is the kind of thing that makes me think, and makes most of us think, that Judge Bev is corrupt. And I don't want her to be. It doesn't bring me any joy to say that Judge Beverly Cannoni is corrupt. It doesn't bring me any joy whatsoever. I wish, for the sake of Karen, for the sake of the people of Massachusetts, for the sake of John O'Keefe's loved ones, I wish that Judge Beverly Cannoni was acting in the interest of justice, because it would just bring us one step closer to getting him justice. And you cannot get justice for Boston police officer John O'Keefe until Karen Reed is free of these charges. This is a hurdle in the way of getting justice for John O'Keefe. And this is why we're fighting so hard for it. We're taking one step at a time. Everybody here wants justice for Boston police officer John O'Keefe. Everyone here does. The issue, though, is that we're being made out to be like, oh, well, no, we're siding with the person who killed John O'Keefe, and so we don't want justice. That's not true. Problem is that we know that they have the wrong person. Common sense dictates that the Commonwealth is trying to convict the wrong person for this crime. And if you are wasting time and resources on the wrong person, well, then you're minimizing the chances of that victim getting actual justice. There's no denying this. Evidence, common sense, all dictate that Karen Reed is innocent of this crime. And at the very least, her rights have been violated. So, and Jen's Tooth, welcome to Logic. Thank you so much. So basically, the Commonwealth files an opposition motion full of a bunch of bullshit. And of course, Judge Bev denies the motion to dismiss and sets the court date for late January in 2025. Now, they, of course, were going to appeal that. This is the appeal. Okay? I hope everybody's caught up. Because it would take me another 10 live streams to explain to you in detail how we got here. So, and I apologize as I'm reading this because I won't really be able to see chat. So, something might catch me on the corner of my eye because I got the chat running on my phone next to me. So, but if I don't see anything that you're saying or any super chats or memberships or anything like that, I apologize. Don't think that I'm not grateful because I very much am. So it goes on to say, now comes the defendant, Karen Reed, who is aggrieved by, I already read that. The order is as it currently stands will result in Miss Reed being retired or retried. I'm also dyslexic, by the way. Retried on January 27th, 2025 for the same 2 alleged crimes, including second-degree murder, that a jury of her peers has already unanimously agreed the Commonwealth failed to prove beyond a reasonable doubt following trial. Because the jury reached a final unanimous decision to acquit Miss Reed on those charges, and because there was no manifest necessity supporting the declaration of a mistrial with respect to charges on which the jury unanimously agreed, retrial on such counts would violate the double jeopardy protections of both the federal and state constitutions and the common law decisions of this court enforcing the protections of double jeopardy. Miss Reed seeks relief from the court through its discretionary superintendent's powers under blah, blah, blah. When I say blah, 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 they're usually citing a past case or some case law, and I don't even know how to read it. In support of this petition, the defense has submitted a memorandum of law incorporated herein and has attached a record including the following statements. A, full docket report. B, Norfolk County Superior Court indictment numbers, blah, blah, blah. Transcript of the charge of the jury. Transcript of jury trial. Interesting. Defendant's motion to amend the jury verdict slip associated with count 2 and supporting affidavit filed June 26, 2024. Transcript of blah, 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 blah. Defendant's motion to dismiss and supporting affidavits, defendant's supplement memorandum in support of her motion to dismiss and supporting affidavit filed July 10th, 2024. Commonwealth's opposition to defendant's post-trial motion to dismiss. Blah, 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 blah. Sometimes I'm just going to skip through this stuff because it's all just stuff that is there in order for these things to be legally binding. And it's a lot of it's very repetitive. A criminal defendant who raises a double jeopardy claim of substantial merit is entitled to review a review of the claim before he or she is retried. And they cite a case law here. Is the appropriate route for obtaining that review. Because the double jeopardy right is a right not to be tried, the court has held that appellate review of the denial of motion to dismiss on that basis after trial and conviction would not provide adequate relief if the defendant were to prevail. The rights conferred on a criminal accused by the double jeopardy clause would be significantly undermined if appellate review of double jeopardy claims were postponed until after conviction and sentence. The court has long recognized that the double jeopardy clause protects an individual against more than being subjected to double punishment. It is guaranteed against being tried twice, put to trial for the same offense. Request for oral argument. Ms. Reed respectfully requests that the court hold oral argument in this petition. Okay, so they're asking to be heard in a hearing. So right there, they're basically just putting it on record that they want to stand in front of this judge or judges to be able to state their case orally and verbally. So it makes sense. And we want Mr. Weinberg to do that, don't we? Because if I remember correctly, I mean, even Judge Bev, when listening to Mr. Weinberg, like, by the time dude was like maybe, I don't know, 3 minutes into his explanation, if that, Auntie Bev was sitting there at her bench, totally at attention, just so yeah. We really hope that Weinberg gets to stand in front of a judge and say these things and argue this case. We really hope he gets to. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. I love that. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. I love it. Prominent, now they're quoting the Federalist. I don't know who, okay, C. Rossiter. I don't know if that's an actual law book. I don't know what that is. But they're quoting the Federalist. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them, in many cases, of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Quoting the United States versus Martin Linen Supply Company. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and powers, should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which he or she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. So far, the translation is, it is absolutely a violation of Karen Reed's basic human rights. Basic human rights to retry her for this crime. Consequently, in a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Blah, 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 blah. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. So again, that translation to that line right there is basically saying that you are possibly creating a new precedent, and it's a real slippery slope. You could be setting a precedent that is a real slippery slope that could create a snowball of just the government being able to trample over American rights. So it's very, 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 this is that line right there explains in a nutshell, but also very clearly why everyone should be concerned about the Boston police officer John O'Keefe and Karen Reed case. Everyone who lives in this country and benefits from the liberties of this country, the liberties that living in this country provides you with, anyone who benefits from this should be concerned. This one line also explains why the people of Massachusetts are so upset and so worried. This isn't just about, somebody who wrote articles independently and informed them of something that was going on, and then them just blindly following this guy. That's not what's happening here. What's happening here is he made these people aware of it. These people started to put together the fact that this could happen. This being that consequentially, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Sorry, that's the wrong line. Thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even through innocent, she may be found guilty. Sorry, that's the wrong line again. Okay, all of that shit I just explained. Sorry, I lost my place. This is... I'm not always funny on purpose, folks. At the heart of this policy is concerning the permitting the sovereign freely, the sovereign being the Commonwealth of Massachusetts, freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Okay. So there you go, guys. Sorry. I hope I fixed it. But yes, would arm the government with a potent instrument of oppression. Yes, words are hard. Here, the very day after the trial court declared a mistrial, counsel for Miss Reed began receiving unsolicited communications from 5 of the 12 deliberating jurors, in 4 instances directly from the jurors themselves, indicating in no uncertain terms that the jury had a firm and unwavering 12-0 agreement that Miss Reed is not guilty of 2 of those 3 charges against her, including the charge of murder in the 2nd degree. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from 1 juror to the same effect, nor the Superior Court judge, who expressly credited the veracity of juror statements relayed in affidavits by counsel, disputed the factual basis for the defense motion in any meaningful respect. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits for the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. The presence and this presents an issue of first impression for this court, as does the defense's alternative contention that Miss Reed was entitled to a post-verdict inquiry to substantiate her claim that this court's proceedings, this court's precedents permitting such inquiry regarding claims of racial bias should be extended to the present context. So they're basically saying right here that that Karen Reed is entitled to an inquiry, meaning that she has the right for the judge to look into this, to ask the jury questions, to go, hey, wait a second. All right, you guys are coming forward here. 4 of you for sure, have come forward. And so what I'm going to do is I'm going to ask all 4 of these jurors, contact the 5th one, find out who the 5th one is. And I'm gonna talk to them individually. I'm gonna find out if their statements were true, and I'm gonna put them on the stand along with all the other jurors and ask them what their verdict was on each charge. So, I mean, I don't see why this is not a very, I mean, if you're claiming this is why I call Judge Beverly Cannoni corrupt, and I do so comfortably, by the way. Okay, this is why I do. Because if Judge Beverly Cannoni, if she is sworn by an oath to make decisions that act only in the interest of justice, and she, throughout this trial, throughout pre-trial, has consistently acted outside of the interest of justice when making decisions, well, then that technically makes her corrupt. She is corrupted. If it is negligence, then that means that she is incapable of making decisions that are in the interest of justice. Okay? That means that we can't rely on her to do so. If it's just negligence, that is still a corruption. That means that her position has been corrupted. So, now on the other hand, if she's corrupt because she is knowingly not acting in the interest of justice when making these decisions, if she is doing anything behind the scenes and showing favoritism, let's call it, for one side or the other, and knowingly making decisions that are in those interests instead of the interest of blind justice, as she is sworn to do, well, then that also makes her corrupt. This is undeniable. So therefore, in my opinion, I am absolutely of the opinion, people. In my opinion, Judge Beverly Cannoni is a corrupt judge. Goes on to say, independently, while a jury deadlock constitutes manifest necessity to support a mistrial, there is no authority for the proposition that disagreement as to some counts constitutes manifest necessity for the declaration of a mistrial with respect to all counts. Put another way, there was no deadlock as to 2 of the counts on which the trial court declared a mistrial. The trial court's finding that Ms. Reed's counsel consented to the mistrial is contrary to both the factual record and the clear binding case law, placing the burden of establishing manifest necessity solely and exclusively on the prosecution. The trial court also failed to address the two guiding principles set forth by this court in Taylor, that before a mistrial is declared, counsel must have been given full opportunity to be heard, and two, the trial judge must have given careful consideration to alternatives to a mistrial, which she did not do. Thus, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution requires the same result: dismissal. The Commonwealth's response on this issue, arguing that inquiry regarding partial verdicts should be prohibited under case law involving lesser included offenses within a single count, unlike the present case, raises an important issue regarding the interaction between the lesser included offense case law and mass criminal blah, 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 which plainly permits and in fact requires the court, before declaring a mistrial, to inquire of a jury whether there exist partial verdicts where multiple offenses are charged in separate counts. Now, that can be very, very confusing, people. That can absolutely be very confusing. So before declaring a mistrial, to inquire of a jury whether there exist partial verdicts where multiple offenses are charged in separate counts. So that piece of paper where there's not a check mark option for not guilty anywhere on it, was very confusing to begin with. This isn't even talking about that. What this is talking about is once the jury sent her that note, once the foreman sent her that note saying that they are at an impasse and there's nothing, they're deadlocked, there's nothing we can do, blah, 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 right? She goes, okay, I'm not going to do that to you folks. Your services are no longer required. I'm declaring a mistrial. As soon as she did that bullshit, right, there was no time between that and getting that note. She read the note. She just declared a mistrial, like right there and then. At no point did she do what the law requires her to do, which is inquire of a jury whether there exist partial verdicts where multiple offenses are charged in separate counts. And I got the found the right line there, didn't I? See? On June 9th, 2022, Ms. Reed was charged in 3 separate indictments with second-degree murder in violation of blah, 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 blah. Manslaughter while operating under the influence of alcohol in violation of blah, 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 and leaving the scene of a collision resulting in the death of violation, blah, 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 blah. A jury trial began on April 16th, 2024. On June 25th, 2024, the jury began deliberations after receiving instructions from the trial court. The court instructed the jurors, you should continue deliberating until you have reached a final verdict on each charge. June 25th, 2024, blah, blah, blah. It also noted that count 2 contained lesser included charges of involuntary manslaughter and motor vehicle homicide, which the jury should consider even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. The following day, on June 26, 2024, outside the presence of the jury, counsel for Ms. Reed raised an issue regarding the verdict form. With respect to count 2, the original verdict slip provided only one option to find Ms. Reed not guilty before going on to ask whether Ms. Reed was guilty of the offense or of the offense charged or guilty of one of those 2 lesser included offenses. See Exhibit B to affidavit in support of motion to amend jury verdict slip. Counsel asked that the form be amended to provide not guilty options for the subordinate charges under count 2. June 26, 2024, at 5, the trial court initially indicated its disagreement with counsel's request. However, after considering the matter further, the court agreed to provide supplemental instructions and an amended verdict slip. Later that day, the court provided the supplemental instructions telling jurors that count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that lead charge, and if the Commonwealth failed to prove the crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. Okay, see, that makes things a little bit more, all right. That makes things a little bit more understandable to me. So what they're saying is, to make it less confusing for the jury, they should have had on the slip, they should have had the most serious charges take precedence over the lesser charges so that the jury would understand that a little bit better. On June 28, 2024, the jury sent the following note to the court. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been able to reach unable to reach a unanimous verdict. June 28, 2024, the court asked counsel for their views on whether they had been due to thorough deliberations. Sufficient to support the giving of a so-called Tui Rodriguez charge. If a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the Commonwealth responded that the charge should not be given because there simply hadn't been sufficient time yet. Counsel for Ms. Reed disagreed. Excuse me. Requesting that the court read the Tui Rodriguez model instruction and go from there. The trial court sided with the Commonwealth, ruling, I am not prepared to find that there have been due and thorough deliberations at this point, so I am going to send them back out. On July 1st, 2024, the jury presented another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or efforts, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. See, now, I feel like that right there should have been something that seemed like a red flag, just the way that, because I feel like in theory, let me explain myself a little better. When they say the divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, I wonder if they're talking about their feelings about certain things. I wonder if the defense should have spoken up and asked, what does that mean? You know what I mean? Because like if that implies what I feel like it implies is that they have strong convictions about certain things. I mean, that could just mean that they have strong convictions about certain pieces of evidence, and that I feel this way, they feel that way, and there's just no budging. Okay, fine. But that wasn't specified. So it's just like when they say just convictions generally like that, I'm like, well, does that mean like, you know, maybe they have strong feelings about drinking and driving? You know, I mean, what does that mean? Maybe they have strong convictions about drinking and driving. Maybe they have strong convictions about, you know, domestic incidents. You know what I mean? Like, what does that mean? But I have to trust that Karen Reed's, defense team is smarter than me and more educated in the law than I am. So I would assume, you know, if that were something that they could have objected to and and asked Judge Bev to inquire further on, then they would have. But, you know. Now, goes on to say, upon being asked by the court, the parties reiterated their same previously expressed views, with the Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Miss Reed's counsel arguing that the court should give a Tui Rodriguez instruction. This time, the trial court decided to give the requested instruction. Later that day, the jury sent yet another note. Thereafter, without reading the note to counsel and without providing counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges, the trial court simply stated the jury is at an impasse and called in the jurors. It then read the note on the record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet their standard and does not sufficiently establish the necessary elements of these charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence of our individual principles and moral convictions. Okay, right there. You see what I'm saying? To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. You guys see what I'm talking about now? Principles and moral convictions. So they confirm that it's about their fucking feelings. You know what I mean? So am I crazy? You know what I mean? Like, guys in the chat, you guys are good about correcting me when I'm talking out of my ass here. But what do you think? Like, do you feel like maybe, the defense should have caught that? I mean, in theory, you know what I mean? Like, again, I'm not a lawyer. I don't fucking know what the fuck I'm talking about, but still, it feels like in theory, like, all right, well, why didn't that get brought up? Well, I mean, are they talking about their feelings back there, Your Honor, or are they looking at the fucking evidence or the lack thereof? You know what I mean? Like, that's, I don't know if I could have resisted doing that. But then again, when I streamed it live, I didn't say shit. I didn't catch it then. So maybe they just didn't catch it. All right. After reading the note and without soliciting the views, oh my goodness. After reading the note and not soliciting the views,
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
David Reese, thank you so much. Bev whispered that she forgot to give the jury the new verdict slip. Okay. Is that in here somewhere? Appreciate that, David Reese. Thank you. And I missed Sassy Bartender's super chat. Thank you, Sassy Bartender. Appreciate it. I wonder if, maybe I just haven't gotten to that yet. After reading the note and without soliciting the views of counsel in any respect, the trial court stated, "I am not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case." The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. The following day, on July 2nd, 2024, unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Miss Reed, Alan Jackson. Juror A stated, now this gets confusing. I get confused when they're talking about Juror A and subject B, and it gets confusing. So don't feel bad if you're confused, because I'm fucking super confused over that shit. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty on count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. 1 day later, on July 3rd, 2024, another attorney for Miss Reed, David Yannetti, was contacted by 2 different individuals, hereinafter informant B and informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. The affidavit of David R. Yannetti, blah, blah, blah. Informant B sent attorney Yannetti, see what I mean? Sent attorney Yannetti a screenshot he or she had received from someone hereinafter of the text messages that intermediary B had received from Juror B. In that screenshot, Juror B texted the following to intermediary B: "It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. I didn't think the prosecution I'd prove the case. No one thought she hit him. No one thought she hit him on purpose, or even thought she hit him on purpose," which later got corrected. Juror B later placed an unsolicited phone call to attorney Yannetti, confirming that the information contained in the publicly filed affidavit was accurate. Affidavit of David R. Yannetti, blah, blah, blah. Juror B clarified, however, that he or she meant to write. No one thought she hit him on purpose or even knew that she had hit him. So there's the correction. Juror B further told attorney Yannetti that he or she believed that every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3. Informant C had been in contact with another individual, intermediary C, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C said no consideration for murder 2. Manslaughter started polling at 6 against 6, then ended deadlock 4 no, 8 yes. Informant C, interesting. If it was no consideration, murder 2. Okay, so basically this is the person talking to the informant in a text message. This is the text message thread between intermediary C and the informant. And so the informant is the one who came forward, obviously, because they're the informant. They came forward with this text message thread. And then they went on to say, interesting, if it is no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. And then intermediary C said she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and the instruction paper was very confusing. Ms. Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending that the jury reached a final unanimous decision to acquit her on those charges, and there was no manifest necessity supporting the mistrial given the evidence that the jury was not deadlocked. but was instead in agreement on those counts. Now, do you guys want me to go on with this, or do you want me to move on to like some of the exhibits? Because this is stuff that most of us already know. Because here's Juror D saying that the jury reached not guilty verdicts on count 1 and count 3, and the disagreement was solely as to count 2 and its lesser offenses. And it says here that he or she recounted that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on counts 1 and 3? So basically what this is what's happening here is someone is stating to Alan Jackson that on the bus ride home, the jury was like, is anybody going to talk about the fact that we acquitted this woman of second-degree murder and she's going to get tried for it again? So we're talking about people who at least a number of them had a good conscience and had every intention of acting in the interest of justice, if not all of them. Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. Juror E similarly stated that the jury was unanimous on 1 and 3 that Karen Reed was not guilty on those charges. Now, I haven't checked chat because I was waiting to see. Okay. Man, you guys are really nice. You guys are awesome. You guys are just like, yeah, whatever you want to do, bro. It's all good. All right. So because Melanie Little went over all of this. I'm curious as to, there's a couple of things that I saw that all right, that's what we're gonna do. Sand and Sea, thank you so much. The exhibits would be interesting. Okay, yeah, I've got that pulled up. I'm just getting it ready. Thank you so much, Sand and Sea. I appreciate you. Yeah, they referenced Alex Murdaugh here, which is interesting. I didn't follow that case closely. Like I know I know the yeah, I know the icing of that case, but not the cake. Like I know it's a chocolate 3-layer cake. I just don't know what the recipe is. But yeah, they cited, because I do know that they had an issue with the I think it was the court reporter. The court reporter did something unethical, and it It affected the case. That's all I really know. I don't know exactly what happened because I didn't follow that case closely. And I remember when it happened. And if you asked me the day after it happened, what happened, I would have been able to tell you, but it's been so long and I just forgot all about it. Okay. Yeah. And I know that if I read this, it'll tell me. I just don't want to. Yeah, this is all about Alex Murdaugh. It's not what I wanted. This whole thing is about Alex Murdaugh. Give a shit about Alex Murdaugh. Okay. Let's see something here. Oh. So this is the motion for the May 24th, 2024 sealed sidebar. They want to unearth that, and I really want to know what that's all about. May 24th. Is that the day that Higgins testified? Is that why everybody's in an uproar about Higgins' testimony? Is that what that is? Okay. So let me do this then. Because that's interesting. That raises some questions. Hold on. Okay. Let me see. Okay, here we go. Now make sure to subscribe to Joe Flip Ahead. Joe Flip Ahead posted this. All right, so this says here, May 24th sidebar, you had a formal interview with some folks prior to your testimony at a prior proceeding.
A little afraid of Brian Albert. All right, so that is the objection sustained.
When the sidebar happened, I think. Let's take a look. Let's take a listen.
A formal interview with some folks prior to your testimony at a prior proceeding. You understand what I'm talking about?
I'm tracking.
Okay. At the formal interview, which is what I'm going to call that.
Okay.
The formal interview, you were asked about Brian Albert and his reputation. Were you not? Yes or no?
Yes.
You indicated in that formal interview that even Chief Berkowitz was quote, a little afraid of Brian Albert. All right, so that is the objection sustained. That's stricken. I'll see you at sidebar.
Okay. That's interesting. Let's hear that one more time.
A little about testimony at a prior interview. You had a formal interview with some folks prior to your testimony at a prior proceeding. You understand what I'm talking about?
I'm tracking.
Okay. At the formal interview, which is what I'm going to call that.
Okay.
The formal interview, you were asked about.
Okay. This is fun stuff right here. So what Alan Jackson is referring to right there, he's alluding to the FBI interview or an FBI interview. He's clearly alluding to that because he's like, that's what we're going to call it, because Judge Bev said that bringing up the FBI, you can't do during the trial. She did this in pretrial. So I don't know yet, Island Girl. We're gonna look into that in just a second. I don't think we're gonna really come up with any answers because again, they're trying to unseal something that's sealed. Basically, they're talking about the sidebar that's taking place right here, right now, and it's based on this. Right now, Lally is objecting to Jackson's line of questioning here. And what they want is for the sidebar transcript to be unsealed. The transcript of the sidebar that's about to take place right here. So let's hear Alan Jackson talk about that one last time and ask that question so you guys have a better context. Because again, Judge Bev ruled that you can't talk about the FBI investigation, the federal investigation into Michael Morrissey's office, which in turn made the FBI look into the investigation into Boston police officer John O'Keefe's death. So this is what they're talking about. This is what he's bringing up. He's because Judge Bev even said, you could talk about it, you just can't say that it was the FBI. You can bring up the fact that interviews were taken, blah, blah, blah. She says something along these lines during a pretrial hearing. But right here, Alan Jackson's following the rule. He's like, okay, well, let's talk about the interview, and we'll just call it Mike B from 413. Thank you so much. According to an ex post by Attorney Betterow, there was also a sidebar about Jackson needing to miss 528, including the manner Bev handled that. I don't fully understand that because I know that Super Chat, of all things, Super Chat should not have this problem. Like if you try to use autocorrect on Super Chats, or if your autocorrect automatically just corrects things without you pressing autocorrect, it will have this weird, it'll type all this weird shit, and then your Super Chat just ends up having gibberish that you didn't intend on typing. So sometimes that happens, and I do apologize for that, but that's a YouTube issue, and hopefully they'll fix that at some point. So I'm trying to hope. I'm hoping to get the context. I'm trying to get the context of what you're saying here. So I know there's a separate sidebar about Jackson needing, but I guess you're saying it happened on 528, including the manner Bev handled that. Okay, so you're saying that Betterow talked about it and how Bev handled that sidebar. But I don't know. I don't know which. I don't know when that was or what. But I hope it comes up. All right, so let's hear Alan Jackson one more time ask this question because he's careful about leaving out the fact that it was an FBI interview.
You had a formal interview with some folks prior to your testimony at a prior proceeding.
You had a formal interview with some folks. About his testimony. Okay, about his testimony at a grand jury hearing, right?
You understand what I'm talking about?
I'm tracking.
Okay. At the formal interview, which is what I'm going to call that.
Okay.
The formal interview.
The formal interview, which is what I'm going to call that. And he's using F words. It's Jackson's slick. You had a talk with some folks, F for FBI, for federal. And you had a formal interview, which is what I'm going to call that. Not a federal interview, but a formal interview.
You were asked about Brian Albert and his reputation, were you not? Yes or no?
Yes.
You indicated in that formal interview that even Chief Berkowitz was
Objection.
a little afraid of Brian Albert.
All right, so that is
Okay, so what Jackson is saying is in that federal interview, he was asked whether or not Berkowitz felt intimidated by Brian Albert. Oh, it's not this sidebar? Okay. Which sidebar is it then, Cherry? I mean, fucking yell at me. Tell me which sidebar it is. Sidebar with Karen. Oh my God. Does anybody know when that happened? Jesus Christ. All right. Well, we're already here. We're going over this anyway. Because this is I'm really interested in what's happening here right now.
is the objection sustained. That's stricken. I'll see you at sidebar.
And it's weird that the question is stricken because I think it's interesting because I would really like to know whether or not Brian Higgins told the FBI. That's a big deal, folks. If Brian Higgins told the FBI that Chief Kenneth Berkowitz felt intimidated by Brian Albert, if that were the case, that answers a lot of questions, does it not? Think about that for a minute. So if Brian Higgins sat with the, I mean, because again, man, is this, why would that even be a question that the FBI would be interested in asking that guy right there? And why is he the guy to ask that? Why is he the guy that the FBI is counting on to ask that? Because that tells me that they're counting on him for information. He's willingly giving information as to the nature of people's relationships that were involved in the investigation of this case. Think about that shit. Why is Brian Higgins the dude for the FBI to sit down and ask questions in regards to whether or not the chief of the Canton Police Department at the time felt intimidated by a resident who happened to be a Boston cop? Dude, you know what I mean? I mean, yeah, man. See, there seems to be a little bit more weight to this proffer. You know, when you think about it in those terms. Because, I mean, you don't just think of motive with criminals, right? You got to ask yourself when it comes to understanding an investigation, you got to ask yourself what the motive is for a tactic that a certain investigator might use. What is the motive behind the FBI sitting down with him in a proffer, in a line of questioning involving a proffer with him, where a question like whether or not the chief of Canton Police Department at the time felt intimidated by Brian Albert. Brian Albert, who some of those jurors stated that they felt intimidated themselves by his presence. On the day of jury instructions, when they were just sitting there, and Brian Albert was sitting there in the one day, just sitting behind Paul O'Keefe and staring at the jury. Why did they feel intimidated by Brian Albert? Sorry, Olivia. Let me check Olivia's messages here. Yeah, but Olivia Nile, it could be something that led to the sidebar that might answer some questions. You know what I mean? I'd like to know what led to the sidebar. Like, this is very telling, even though it has nothing to do with what we were talking about. We completely went off track here. But I'm glad we did. So yeah, I'm sorry, Olivia. I wasn't looking at chat. Olivia was saying the sidebar, the refer to in filing in Bev seeking Karen's consent was a showing of proof by the defense that the judge allowed time for consent from the defendant for far less pressing issues. The sidebar that they're referencing in the filing, Bev seeking Karen's consent, a showing of proof that's I can't tell how you worded that is. And it was specifically spelled out in the defense's appeal. Okay. Will, the sidebar was about Judge Bev inquiring for Karen's consent if okay for Yannetti to represent her the day AJ would be there. Oh, yeah. Okay. Okay. That's interesting. Okay. Yeah, I just didn't get to that point. All right, I understand now. Thank you. And right, when Jackson, I remember all of this. Okay, I remember all of this. Yeah, okay. I remember all of that shit that day. Okay. I remember them talking about it. Yeah, it was at the end of yeah. All right, let's see what this is, because I'm sidetracked here. I'm sidetracked. We'll get back to this, but my wheels are turning about this right now.
May I inquire?
Yes.
Thank you, Your Honor. You're also relatively close friends. In addition to being close friends with Brian Albert, you're also relatively close friends with his brother, Kevin, correct?
I am.
Kevin Albert is a detective.
All right. So right there. So Kevin Albert is Brian Albert's brother. Kevin Albert is also a Canton police officer. Kevin Albert, as I understand it, I haven't looked too deeply into that, but as I understand it, is back on full active duty. Is that true? Hey, Corruption, thank you so much. Appreciate you. Because I know he basically got sent on a paid summer vacation from Chief Rafferty. Yeah. Okay. So for those of you who don't know, Kevin Albert, he's a Canton police officer. He's the brother of Brian Albert and Chris Albert. Chris Albert, who sits on the Canton Select Board, and Brian Albert, Kevin Albert, during trial, during Michael Proctor's testimony, who is now suspended without pay and works for the Massachusetts State Police, who supposedly has very loose ties with the Alberts. This person knows this person to that. No, they're friends. Okay. Michael Proctor is a friend of the Alberts. He's a friend of the McCabe's. It's been established. Again, another attempt at misdirection from the prosecution, which failed because Michael Proctor testified in open court that he and Kevin Albert were out drinking, and Kevin Albert they were out drinking, and Kevin Albert left his badge in Michael Proctor's car and couldn't remember if he left his gun. So, yeah. And so for this behavior, Chief Rafferty put him on administrative leave with pay indefinitely, and now he's on full active duty again, which is so comforting. It's so comforting. The Petty Paralegal just gifted 5 memberships. Congrats to all you guys. Thank you. Wow. Awesome. Yeah, no, we've got a lot to go through, so I'm not doing the super chat dance unless it's requested. If it's requested during a super chat, like in a super chat, then I'll play it. But in the meantime, it's suspended at the moment. It's on administrative leave with pay at the moment. Yeah, so now, yeah, Kevin Albert is back on duty. I mean, I think it's safe to say that the Alberts run that town. Like, literally, Chris Albert sits on the select board. The Alberts run that town. And there's no corruption? Supposed to think there's no corruption? It's very interesting. So here, Brian Higgins most likely told the FBI that Kenneth Berkowitz, the chief of police at the time of John O'Keefe's murder, Chief Berkowitz was intimidated by Brian Albert, whose lawn John O'Keefe's body was found on. Now, I recently went over a video by a creator called Mass Corruption, who's a video audit channel. And and he took a video of he took a video of a Canton police cruiser on October of 2022, and it was missing the entire taillight housing on the passenger side, and the housing was inside of the car with absolutely no taillight in it. And there were 3 extra pieces in the reconstruction of the taillight during trial that did not fit the reconstruction of Karen Reed's taillight. So there had to have been a source outside of Karen Reed's vehicle for that taillight. And I seriously doubt that it's a coincidence that Canton police cruiser, when that video was taken, that had expired inspection stickers on it, was being driven by Ken Berkowitz's son. Yeah. It was being driven by Ken Berkowitz's son when the video was taken. And no body damage anywhere surrounding the car either, which is also bizarre. Thank you, Olivia. So why was there no body damage around that part of the car? I mean, why was the taillight removed? For what? What purpose was that taillight removed? Because obviously it was removed. Did that taillight just happen to bump into somebody else's elbow and attack it like a dog? Is that what happened? Because that's the only thing that would make sense, really, wouldn't it? So, yeah, a lot of shady shit going on here. So I guess, hold on. There was stuff that I wanted to go over, man. That was in one of these filings, and I just can't remember what it was. Yeah, the whole thing's about Murdoch. Hold on. Sorry, guys. Give me just 1 second here. I guess I just don't have. Okay. Never mind then. I do, you know what? There's part of that that I stopped reading that I wanted to continue reading, actually. I just have to find my place. Okay. I wanted to go over the verdict form thing. Okay, so it says here, the following day on June 26, 2024, outside the presence of the jury counsel for Miss Reed, raised an issue regarding the verdict form. With respect to count 2, the original verdict slip provided only one option to find Miss Reed not guilty before going on to ask whether Miss Reed was guilty of the offense charged or guilty of one of the 2 lesser included offenses. Counsel asked that the form be amended to provide not guilty options for the subordinate charges under count 2, June 26, 2024. The trial court initially indicated its disagreement with counsel's request. However, after considering the matter further, the court agreed to provide supplemental instructions and an amended verdict slip. Later that day, the court provided the supplemental instructions telling jurors that count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that lead charge, and if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. Right. On June 28th, 2024, the jury sent the following note to the court. I am writing to inform you on behalf of the jury that despite the exhaustive review, diligent consideration of our disputed evidence, we have been unable to reach a unanimous verdict. The court asked counsel for their views on whether there had been due and thorough deliberation sufficient to support the given of so-called Tui Rodriguez charge. After due and thorough deliberations, returns to court without having to agree. Having agreed on a verdict. Okay. I've already read that. Let me hold on. Let me get to this part here. After hearing oral argument on August 9th, 2024, on August 23rd, the trial court issued an order denying Miss Reed's motion to dismiss. The court accepted, for the purposes of the motion to dismiss, that the juror statements quoted in the defense affidavits were true and accurate. Order at blah, blah, blah. It went on to hold, however, that because there was no open and public verdict affirmed in open court rendered in the case, the defendant was not acquitted of any of the charges. Wow. Okay, so let's talk about that for a second. Let me just go ahead and share the screen there too while I'm at it. You guys don't have to stare at my ugly mug. While I'm reading it anyway. So let's talk about that for a second. So it says here, it went on to hold, however, that because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges. So basically what that's saying is, because the jury never stood up and addressed the court and said, Your Honor, on this charge, and this charge, we find the defendant not guilty on counts 1. We find the defendant not guilty on count 3. Because they didn't do that, that's why she wasn't acquitted. But what Judge Bev is failing to explain here, because this is what this is doing, is quoting her denial of that motion to dismiss. What she's failing to put here is that she never gave them the opportunity to do that. She never said, hey, what counts are you stuck on? All right, so you guys are unanimous on counts 1 and count 3. All right, so then I'm declaring a mistrial on count 2. Because she never presented that situation. She never created that scenario for the jurors to be able to do that. It didn't happen. But here she is basically blaming the jury and saying that the jury just didn't do that. Hey, the jury didn't do it. The jury didn't stand up and say, hey, That's it. Amazing. The court similarly rejected the defense argument regarding lack of manifest necessity, finding that Ms. Reed's counsel consented to a mistrial via their failure to object. And the jury notes reflecting an impasse established the requisite manifest necessity. The court did not address the Taylor test for declaring a mistrial based on a manifest necessity, nor did it address Ms. Reed's contention that the burden of demonstrating manifest necessity is squarely on the prosecutor. The court instead erroneously equated a request for a Tui Rodriguez instruction, which is designated to encourage a verdict, with consent to a mistrial. Finally, the court rejected the defense's alternative request for a post-trial inquiry on those issues on the grounds that the request implicated the substance of the jury's deliberations. Ms. Reed's retrial is currently scheduled to begin on January 28th, 2023, or 2025, excuse me. That's funny. The jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Okay. So, yeah, just because there's a lack of check marks on a form, that doesn't mean that has to determine the fate of someone's life. I mean, that's insane. That's insane that's Lally's argument, and Bev is like, oh, well, you're right. No, dude. Like, you don't get to just say, all right, well, you know, they didn't check the form, so forget it. This isn't fucking Jeopardy, bro. This isn't Jeopardy, dude. Like, I mean, think about that shit. What the fuck are these people thinking? Objection, Your Honor. The defendant failed to ask what, if any, prior to asking their question. Okay? She didn't answer in the form of a question, Your Honor, so she should not be awarded points. What? It's the stupidest shit ever. Oh, they didn't mark the check mark. So fuck it. You know, we get to decide whether or not she gets thrown in prison for the rest of her life. Should have checked the mark. That's not how fucking life is, bro. Like, that is not in the interest of justice. The check boxes are merely a tool used in the process of the pursuit of justice. That's all. That's all. That's all. And yeah, she did say that too. And if it's not checked, then it's not guilty. So, like, this makes no sense. This is the stupidest shit ever. Here in the affidavits by attorneys Jackson and Yannetti reflects statements by 5 deliberating jurors, and the jury had reached final unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3. There was nothing tentative about juror statements. To the contrary, they were definitive in describing the result of the jury's deliberations. Juror A was emphatic that count 1, second-degree murder, was off the table and that all 12 of the jurors were in agreement that she was not guilty of such a crime. Text message from Juror B is, it was not guilty on second degree. No one thought she hit him on purpose, or even if she knew that she had hit him. So that's the whole thing is this is what makes it a no-brainer for me. This is what makes it an absolute no-brainer for me. Okay, so if this jury, all of them concluded she didn't even know if she hit him, she didn't even know that she did. Right? So there's that. There goes intent, there goes motive, there goes all that shit, because all those things are moot points. They don't matter now. Motive, opportunity, none of that shit fucking matters anymore if the jury doesn't even think that she did it on purpose or even knew that she did hit him. So right there, all that shit is off the table. So right there, all right, you have involuntary manslaughter possibly on the table. But the problem with that is that means that Karen Reed still hit Boston police officer John O'Keefe with her SUV. And the big problem with that is there are two independent experts, two experts with PhDs independently hired by the FBI to determine whether or not Karen Reed hit John O'Keefe with her SUV, whether or not John O'Keefe was hit with Karen Reed's SUV. That's what they were brought on to testify to. They were not solicited by the defense monetarily, at least. They were subpoenaed because a completely separate, independent federal investigation into the death of John O'Keefe was taking place because they were investigating how the investigation was conducted. And based on everything that happened in that trial, there is clear, good reason for that. Clear, good reason why the FBI should be investigating how this investigation was conducted. There is many, many reasons for that. That was gone over in trial. That was exposed during trial. Because there is clear, this post-trial, they're showing reasons for this because many of the officers, all of the lead investigators of this case that testified at this trial are now being internally investigated by the Massachusetts State Police. That's happening. So why is this even a thing? This is the craziest shit in the world, dude. And I know that Turtle Boy was referenced here. So in an appeal to the Supreme Court, Turtle Boy's mentioned. I haven't gotten to that part, but he's mentioned and referenced based on what one of these jurors has said. And I haven't read that. Maybe we'll do that. Maybe if we got some time, I'll go over Turtle Boy's interview, his last interview with this juror. I as I understand it, they didn't even talk about the ARCA experts. That wasn't even on their fucking radar. They just dismissed the ARCA experts as if they were just insurance guys. I mean, this is wild, man. This is absolutely wild. In rejecting Ms. Reed's claim of acquittal, the court relied solely upon the lack of an open and public verdict affirmed in open court. The reasoning is rooted in a formalism that has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. However it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. Holding that judicial grant of a new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize trial judges to enter judgments of acquittal in jury trials. Indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. And in the context of this highly publicized case, it strains credulity to suggest that if the unequivocal statements of the 5 jurors quoted above did not, in fact, represent the unanimous view of all 12, the remaining jurors would allow the inaccuracy to go uncorrected. Instead, they would predictably have noted the Commonwealth or the court of their own recollection. Yeah, it was funny. I was watching Melanie Little's stream for a little bit there, and she talked about this term here. Hold on, I have to find it again. Strains credulity. And I had to Google the meaning of that. And then I helped out the chat just in case there were people just as uneducated as I was on that. Strains credulity. I'll use that word in a sentence. It strains credulity that Plevin would say anything that is worth listening to or anything worth reading while scrolling through Twitter. It strains credulity that Jennifer Coffendorfer should be credited as an FBI agent at this point. Probably still not using it properly, but the United States Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberation had not yet concluded, and it went back to the jury room and it went back to the jury room to deliberate further. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of deliberations and following. The contrast with juvenile versus Commonwealth is even clearer. In that case, after the conclusion of trial, a court officer found 4 verdict slips in the deliberation room, 2 of which reflected entries of not guilty, which was no indication as to when the entries were made or in what circumstances, much less that they reflected a final unanimous conclusion of all jurors. Neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because such final unanimous agreement was not announced in open court. Counsel arguing that blah, 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 blah. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. Okay, yeah, that's fucking crazy. Should have spoke up. That's the justification. You should have spoke up. Now, this is interesting because I'm really interested to see what the Supreme Court says about this, because I doubt that there's ever been any case like this, right? Something this high profile, that's amazing. Something this high profile, and jurors coming forward and going, hey, something's wrong here. You guys should know that we all voted unanimously, and we're all pretty much willing. I mean, I don't see why anybody wouldn't be willing to testify that we all voted unanimously not guilty on counts 1 and 3. There's no reason why. I mean, put a Bible in front of us, you know what I mean? And we'll swear to it, you know? This is wild, man. I've never seen anything like this. And here they cite now this I'll get into, because this is about the Murdaugh thing, but in another high-profile case, the South Carolina Supreme Court recently agreed to hear claims by Alec Murdaugh or Alec Murdaugh is how you say his name, actually, from what I understand, Alec Murdaugh, that during the murder trial, the clerk of court improperly influenced deliberating jurors. Order attached here too. Jurors came forward after the clerk published a book about the trial describing her efforts to obtain a guilty verdict through improper jury tampering. Brief of appellant attached here too, blah, blah, blah. The clerk allegedly told jurors after the defense began its case not to let the defense throw you all off or distract you or mislead you, and warned them not to be fooled by Mr. Murdaugh's testimony in his own defense. The trial court held an evidentiary hearing on the motion for new trial, including testimony by jurors. The issue is not racial bias, but nonetheless implicated fundamental constitutional rights, like Miss Reed's right not to be retried for offenses of which she has already been acquitted. The trial judge dismissed Miss Reed's reliance upon Sarneff and Murdaugh in a brief footnote, simply stating that the circumstances are readily distinguishable from those at issue here. But this misses the forest for the trees. While it's certainly true that all 3 cases raise different issues, the fundamental point remains the same. A defendant who comes forward with credible evidence of a serious constitutional violation post-trial is entitled to an opportunity to prove those claims. This is very, very important. The point here is not the how, it's not the who, it's not the why. It's the if. It's the if. Did this happen? Did this happen? If the defense comes forward and says, hey, this fucking happened, man, then the defendant has the right to prove those claims. That's what they're stating here. That's basically all of this boils down to. That's basically everything here. Everything that's going on right now is basically this in a nutshell. Is the jury came forward, said that they voted unanimously that Karen Reed was not guilty of murder and should not be retried on that charge. The defense filed a motion. The defense made the court aware of this, filed a motion to dismiss on this, and then asked the court if they could have a formal inquiry as to what each juror's verdict was. Not what they talked about, not how they got to that verdict, what made them think they should lean towards that verdict, just what was the verdict, guilty or not guilty on that count. Each juror, sit them down, have them formally testify to it. That is all the defense was asking, a formal investigation into the defense's claims, a chance to prove what she was saying is true. That's what this boils down to. That's it. And she was denied of this basic human right. This is, I mean, that's what our laws are based on. Our rights, our American rights, are based on human rights. That's why we say, bring us you're hungry and you're poor. That's why we say that shit. Because we believe that every human being, our forefathers believed that every human being was entitled to rights. So once you get here, once you land on this soil, you are entitled to those rights. And we have laws that will protect those rights for you. That's the whole point. This is a violation of those rights. Karen Reed is being robbed of those rights. The trial judge dismissed Miss Reed's reliance upon blah, blah, blah. In a brief, I'm not reading that again. Footnote, simply stating the circumstances are readily distinguishable. Did I already read that? Or are they writing that twice? Oh, I did already read that. There is no apparent reason to artificially limit the availability of such constitutional inquiry to the singular context of racial bias. The defense request does not in any manner infringe upon the substance of the jury's deliberations. Meaning, again, they're not asking what was said in deliberations. They just want to know, what did you decide? Each juror, what did each juror decide? Guilty or not guilty on each individual charge. To the contrary, the motion to dismiss was predicated solely upon the result of such deliberations, namely a unanimous decision that Miss Reed is not guilty of murder in the second degree. The relevant inquiry could be accomplished by a single yes or no question posed to jurors. Right. Did you unanimously acquit Karen Reed for the charges in counts 1 and 3? Yes or no? Of course, the results of a jury's deliberations are not secret. They are, in fact, routinely announced in open court. Here, the defense has learned post-trial that the jury reached a verdict that was not so announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Miss Reed is not unconstitutionally forced to stand trial for criminal offenses of which she has already been acquitted. Again, meaning that the judge should have asked the jury specifically which charges and had them announce it in open court before she declared a mistrial so hastily. That's what this boils down to. They would have absolutely done that. The jury coming forward is them saying, well, if she had told us, if she had asked us to stand up in open court and say what our verdict was unanimously, we would have happily done that. But the problem is that she never asked us to. She never did. So this is a Judge Bev thing. This isn't a jury problem. This isn't the jury that fucked up here, and it's not the defense that fucked up here. Because the defense didn't have to object and go, hey, Judge Bev, are you going to do your job? You know what I mean? That's not what the defense's job is. I mean, it is their job to do that if they can catch it. But they shouldn't be playing keep away with the judge. They shouldn't be watching the judge. They shouldn't be keeping track of every single little thing the judge does, worried about what they're going to object to. They're too busy worrying about what the prosecution is going to object to because the judge is supposed to be fucking impartial. So why would the defense be on defense from the judge and the judge's decisions? Think about that. So you're saying because they didn't object to the mistrial, I mean, that's your job, Bev. In the interest of justice, your job is to instruct the jurors to tell you and tell the court which charges they were at an impasse on. But they didn't do that because you didn't give them the opportunity to do that, Bev. And you don't get to say, well, I got to slip one by the defense. Because that's basically what you're saying without saying it. I slipped one by the defense and they didn't catch it. So here we are. New trial. That's not in the interest of justice at all. That is absolutely bizarre, man. Right, you can appeal. Right, I get it. I just used the wrong word, but I mean, maybe that's exactly what they had in mind. Maybe that's exactly what the defense was thinking. Like, well, fuck. Okay. Because, I mean, think about it for a second. Like, how would that have gone? let's speculate a little bit. We watched the trial. How would that have gone? What if Alan Jackson stood up and go, "Hey, Your Honor, wait a second. You're calling a mistrial." Think about it. How do you think Auntie Bev would have handled that? You don't think she would have been like, that's my decision now. I've already made my decision. Jurors, you are excused. I've already excused Mr. Jackson. You can sit down. I've already excused the jurors and their service is complete, and I am not going to put them through anything further. Thank you. Have a good day. That's what she would have fucking done. And you know it. Everyone here knows it. Mr. Jackson, my decision has been made. You can file an appeal. She would have totally done that shit. So we would have been here anyway. That's what's really funny. Never occurred to me until this very second, right now. We would have been here fucking anyway. Right? We would have been right here anyway. Defense had this in mind the entire time, more than likely, because they didn't put up a fight, because they didn't stand up and go, "Wait a minute, Judge Bev, are you gonna, I mean, which counts?" Mr. Jackson, sit down. Yeah, this is fucking crazy, dude. Yeah, we would have been here inevitably anyway. That's what's fucking crazy. We would have been here anyway, dude. Fucking anyway. At any given, it wouldn't matter. Dude, she was so quick to declare that mistrial. It's not even funny. She was so quick to declare that mistrial. She knows better. But again, remember I was saying that whole time when we were waiting to find out what she was going to do? I was like, she's not going to grant that dismissal. She's going to deny it. Why is she going to deny it? Because that would mean that she would have to admit to wrongdoing. Her ego will not allow this. This mistake is on Bev, nobody else. I said that when it happened. I was like, when those jurors came forward, I said, this is a Bev problem. She fucked up. And so now, I mean, I'm sitting here and I'm like, still giving her, like, just subconsciously giving her the benefit of the doubt. Just because I believe and respect, our justice system so much. Just because I do, just because I have so much faith in it, I'm realizing that I'm doing this, that I still give her the benefit of the doubt. That's what's fucking crazy. Even though I know I can see right through all the corruption in this shit, right? Just because I have so much faith in our American justice system and the ideals and the principles that it's built on. Like I still have faith in Judge Bev because she wears that robe. Without thinking about it, without seeing Bev herself, automatically I see the robe. I never realized that my faith in the justice system went that deep. That her wearing that robe has that much effect over the things that I expect. Regardless of the fact that she has shown me otherwise. Consistently, since pretrial, she has shown me the opposite of what that robe represents through her words, through her actions, She has shown me the opposite of what wearing that robe represents. And I still give her the benefit of the doubt because she has that robe on. That's how much faith I truly have in our American justice system. It's crazy. Never thought about it until right now. Yeah, the placebo effect. It's fucking wild, man. It's absolutely wild. Yeah, I mean, I know, I get it, Scott McGinnis, but you're missing my point. What I'm saying, though, is that I never really like tried to visualize the faith that I truly have in our American justice system and how strongly I believe in the ideals and principles that it's built on. I never really tried to visualize it before. It's crazy. No, I don't blindly trust a uniform. You guys are missing my point. You guys are missing the essence of what I'm trying to say here. Most of you aren't. A couple of you are. Sorry, I'm just trying to find. Yeah, this is all stuff that you should hear from a law tuber. Okay. Let's do this. All right. Phone lines are open, folks. Anybody wants to call in? Call that number right there. Hey, Corruption, have you not gotten your merch yet that you ordered? How have you not gotten that yet?
Call from Jojo.
You're on. Who am I speaking with?
Hey, Claire, how are you?
I'm
It's
fantastic.
Josie.
Hi, Josie.
You just lit one up, so I'm gonna lit one up. So, my concern in regards to Kevin Albert, the fact that he came back or they brought him back to Canton PD. Does anybody know if he's back in full capacity or he's active, or do you think this is a mechanism to do what it is that we need to do with him, or what?
Kevin Albert?
Yeah.
Oh, Kevin Albert, as far as I'm concerned, that's just proving what Rita was saying when I was speaking to her on Brian LTL's channel.
Yeah.
Rita was saying that's nothing. They're not doing anything. That's just something to pacify us for the moment and try to keep us quiet and pacified.
I don't think so. And I don't think so because don't forget, him and Lank were the first ones at Sandra Birchmore's apartment in Canton.
Okay.
Lieutenant Gallagher is now filing he just submitted his request for retiring.
I want to make sure we're having the same conversation here. You're talking about Kevin Albert being reinstated into the Canton PD, correct?
Yep.
Mm-hmm. Okay.
Yep.
That's what I'm trying to tell you is he was only suspended. He was only put on leave in the first place just to pacify everyone.
Yeah.
Otherwise, he wouldn't be put on active duty again. This was all done internally within the Canton Police Department. This doesn't have anything to do with the federal investigation.
But I have a little feeling that it does. Like maybe they brought him back so they can have him close, active, so they can finish doing what they're doing. Don't forget, he and Lank were the first ones at Sandra's apartment. Lieutenant Gallagher is trying to bail out by filing for retirement.
I see what you're saying.
I think this is all very weird.
You think that it's a ploy to because of his misconduct in the Sandra Birchmore case, or his alleged misconduct in the Sandra Birchmore case, that they brought him back, put him on full duty to collect information as a mole, maybe, as
or something,
a double agent.
Something. This is, things don't happen out of coincidences here. There's a reason behind what they're doing. Even when they send him out on leave, there's a reason behind things. We may not know them yet. We may know them later, or we may not. I don't think there are coincidences.
I agree with you. There are no coincidences. I do. I don't think that it's a coincidence. I just disagree with you on the reasons why he was suspended and then brought back. Canton, you got to think. Canton is different than the Massachusetts State Police. What's going on in Canton is very, very tight knit, and
yep.
The behavior of the Canton Police Department and the behavior of people on the Canton Select Board, they basically rub this behavior in everyone's face and say, well, there's nothing that you can do about it. We don't care. People bring it up at the Select Board all the time. People talk about this stuff at the Select Board, and all they do is they're just meeting their requirement to allow the people time to speak, and that's all they're doing. They're not doing anything other than that. But they're basically saying, okay, yeah, you talked next. Okay, yeah, you talked next. But they're not doing anything about it. Now, Kevin Albert being suspended by Chief Rafferty, that doesn't.
Can you call her Raggedy? Can you call her Raggedy?
Sure.
Raggedy.
Well, the suspension that was a decision made by Chief Raggerty, and the decision to bring him back was also made by Chief Raggerty. So I don't think that necessarily, unless that this definitely bringing him back would not be to create an appearance for the feds. So I think that they're just basically doing, putting on a business as usual act. Oh no, everything is fine. If they suspend him without pay, or suspend him indefinitely without pay, or they fire him even, or conduct an internal Canton Police Department Canton Police Department investigation, which hasn't been done on anybody yet. Then if they do that, then it looks like there's something wrong with the department. So I believe the reasons why Chief Raggedy did what she did with Kevin Albert is simply because she wants to continue the appearance that, oh, everything's fine at the Canton PD. There's no reason. Why would we suspend him? Why would we fire him? Why would we charge him with a crime? Because maybe that might put them in a position to where they could be implicated in something. Maybe if they actually did do something, then Kevin Albert might have something to say in regards to the Sandra Birchmore case that might implicate other people. But the problem with that is he's an Albert. So I don't think that that's the case because he's an Albert. I think it's more along the lines, since Berkowitz was probably intimidated by Brian Albert, then everyone else, including Chief Raggerty, is intimidated by Brian Albert in some way, shape, or form. And if she's intimidated by Brian Albert, that means to some degree she's intimidated by Kevin Albert. And I think that's why he got just a little slap on the wrist and a paid vacation, and now he's back on duty. That's what I think.
So, and as far as the jurors go, is there like a common denominator? Why were they were so focused on, well, it was the data, and not looking at, I don't know if anybody noticed, but anything that was logically highlighted or that would catch anybody's attention, they dismissed it. They were not focused on that. They were focused on the data and the cert and the pieces, and they didn't care about Proctor. They didn't care about this and that. They didn't put attention to,
who didn't care about that?
That's what the juror said on the second part of the interview.
The interview, okay,
the majority of them didn't care about, Jennifer McCabe or whatever he said, or they didn't care about the.
They thought it was a defensive tactic to misdirect.
It was a tactic. It's like so. I kept asking, does anybody know the age group of these kids? Because are they ADHD? Are they like failing to catch what's obvious to most?
What you have to understand is when you're a juror, you're instructed to look at things that are strictly evidence. And
granted.
Okay, right. So that's why they were focused on the CERT team. That's why they were focused on the physical evidence and the data. Because A, it's very confusing. And so I could imagine that they had to spend a lot of time focusing on that. And B,
they didn't understand.
Okay.
I'm sorry. Go ahead.
Go. B is the fact that the defense are usually the ones who would use a misdirection tactic, not the prosecution. They would not expect that. The jury is never going to even take that into consideration right off the bat or instinctively, that the prosecution would be the ones playing misdirection games with the jury and not the defense. So immediately they're going to assume it's the defense because that's the defense's job generally.
I understand, but don't forget,
is to distract the jury with details, with a lot of smoke and mirrors. And I don't blame them for looking at the jury, looking at the McAlberts as smoke and mirrors. But I feel like at least one of them should have spoken up and been like, no, wait a minute. I get it.
Yeah, but regardless of whether you're the foreman or not. Yes, absolutely.
Right.
But if you think about it, fine, they have to look at the evidence. But there's also the lack of evidence. At one point, they asked for the 13. And what they said was, the evidence you have is the evidence you have. They didn't give them any explanations as far as the fact that there was no 13 to begin with. Now, how do you explain that 45 pieces of taillight were found around where John were inside the curve? They were not on the street where a car would actually hit somebody. They were where they found him, which was away from the curve. So, and they found every single one of them and were able to put them back together with a puzzle. How do you do that? And if that happens, I mean, what I'm trying to figure out is, come on, people. It's like, this is plain stupidity. You have to have evidence, but where is the evidence? Where was it found? And how were you able to find 45 pieces of taillight? And they ignored completely the video of Karen coming out when she actually hit the Jones SUV. They ignored that. So even though they saw it moving, it was impossible for them that the taillight probably broke there, and that during the time lapse that they had the car, they didn't notice that. It just amazes me.
Here's the thing is I'm really glad you brought that up because I was in the courtroom when when the jury saw that video of Karen backing into John's SUV, right?
The tire move.
I saw the jury's reaction. Okay. Now, the only juror that visibly reacted to that was juror number 3. And juror number 3 was dismissed before deliberations. And allegedly by Fanning, because Fanning allegedly was supposedly the guy in charge of the jury. So so that should tell you something because I saw with my own eyes. I didn't hear through the grapevine or anything. I saw with my own eyes. I saw that juror react to that footage.
So, and they bring 2 experts to talk about the 227 search, and their response. Well, the juror that Turtle Boy interviewed responded that they didn't give attention to that. They didn't merit that. They didn't think anything of it. Like it was irrelevant. It's like, so what were you guys doing? Catching Pokemons in the courtroom? What the heck is going on? It's like, you're right there. All of this stuff is weird. All of the testimonies is weird. You can tell that people are lying in your face. And they think that there's an insurance company or Turtle Boy is paying for the art. I'm in awe because if anything happens to any of us and we are facing murder charges, these are the people that are going to be deciding the rest of our life.
Right.
And you have to have a little bit of common sense. I'm not sure how this jury was picked. I don't know the background in the interview that says that they're a very smart group of people. I doubt that. And if they are in a specific area of expertise, like if somebody is this or somebody's that, maybe. But they have no logic, no common sense. And there's a lack of dedication that I perceive that they didn't put into this, understanding the charges that Karen is facing. It's
like,
it's irritating.
I used to I used to like doodle line cubes. You know what I mean? And
no.
You don't know what I'm talking about? Like when you draw a cube, you know?
Yeah.
Yeah. So, and I used to trip out because, you know, this is the kind of dumb shit I would do in school during class, right? Bear with me because, you know, I'm getting to a point. Yeah.
To make sense of things.
The little 3D cubes, right? So now I used to trip out looking at them instead of paying attention to my teacher when I would draw them because there would be a perspective, you know, I'd look at it and there'd be a perspective that the cube was going this way. And then I'd look at it from another perspective and then the cube was going this way. I would never look at it any differently. It was just be how my eyes would perceive it. And I would always be like, wow, it's wild. My eyes are perceiving the cube to go, and it's not any different. It's just a question of perception. So my point being is the jury is looking at this cube from the perception that the defense is going to try to distract the jury, right? They're not thinking, it's not even a thing for them to think that the prosecution would be doing that. They're going to assume, that the prosecution is acting in the interest of justice. They're going to make all of their decisions based on this. So what you're talking about is the reason why you and I would not get picked for that jury is because we know too much. We knew too much pre-trial. We know too much about the case. We already have the perspective of side-eyeing the prosecution going, I wonder if they're shady.
Claire, but actually, let me ask you something. Before we knew anything about anything, I am sure that 99.9 of us, by the time that the news broke and we saw the pictures of his face, you didn't think that was a car, did you? Because I sure didn't.
You got to understand, the jury wasn't familiar with the case. That's how.
And at the end of the day,
that's how juries work. They
reasonable doubt.
Okay, right.
At the end of the day, reasonable doubt.
And there was reasonable doubt. That's why
But
the
yet
jury
again-
has to be unanimous on a guilty verdict. Not one
But
out
they
of
spent-
not one out of those three counts. Not one out of those three counts did the jury unanimously meet a guilty verdict. So there's your reasonable doubt. They considered the reasonable doubt. Like reasonable doubt would have gotten Karen acquitted.
Okay. So the way I see it is, if they were okay on 1 and 3, and they were fine on those 2, and they were able to get to a consensus, but they had doubts, and they were half a split. First it was 6-6, and then it was whatever, blah blah blah. That means that there is reasonable doubt on the manslaughter charge.
Sure.
So that should have been enough to say we are at a pickle here. You guys think that, we think this, and we have a reasonable doubt to declare this not guilty. So why wouldn't they do that?
But that's what happened.
Yeah, no. Fill out the damn form, put not guilty on 1, not guilty on the 3rd, and reasonable not guilty on the second one.
I see.
Why wouldn't they do that?
You're talking about certain jurors. Okay. Those certain jurors are they explained in the note that they wrote to Beverly Cannoni. They feel strongly in their convictions and they are not budging. They feel that she's guilty of manslaughter. You know, I mean, there's nothing you can do about that. That's the impasse. Now, I agree with you. That's I had this same rant and rave that you're having right now. Back when
I have it every day with myself, with the mirror, with the TV, with you, with Cutter Boy, with everybody watching, by myself. The dog thinks I'm crazy. This is just pathetic.
Back when the mistrial first happened, I was saying that I was like, I don't understand how anybody. I mean, if you understand the concept of reasonable doubt, then why could you?
Then why
were you so adamant that she was guilty of any of these counts? They didn't prove their case in any way. I don't understand this.
So I get what you're saying.
But it doesn't matter.
Day,
it's futile to do that to yourself. We are where we are. You know what I mean? Like,
yeah. And the judge was, she did this from day one. She set it up. She knew what she was doing when she set it up, and the charges the way that she set it up. She knew that one way or another they were gonna get hung, because they not only with the verdict form missing the not guilty in the first form before it was corrected and giving Jackson all of this hard time about it, but also by saying you do not come back to me at all until you are unanimously in agreement in all of the charges. You do not come back to me. And that was a mistake. I don't know why that. I don't know whether the lawyers can actually audit these forms or agree on this or have a consensus on how this thing is going to read.
Well, they did argue the form. They did.
No, and what about the judge instructions? Why is the judge allowed to tell the jury, you do not tell me nothing, you don't come back to me, you don't talk to me, you just send me notes here and there, and you don't come back or do not fill out a verdict form until you come to an agreement in all of the charges? Why is that? And the other thing is, why is it that Massachusetts doesn't have the transcripts for the testimonies?
Right.
Do you know how easy it is to get confused with 73 people coming over to talk blah, 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 and bore these people? They're trying to catch Pokemon and they're bored out of their minds. And then they couldn't even tell that Lucky Lochran was the one who said, man, I didn't see the guy. I went twice. He wasn't there. I had lights all over the place. It looked like a baseball field. Fenway was a little bit lower than my lights. And I didn't see him. And they thought that Lucky was deceiving. Oh my God. This is just pathetic. But look, I'm probably killing your audience, so I'm gonna let you go so you can take more calls.
You're fine. I saw you had a Broward County area code there. You from South Florida?
Well, it's I've been everywhere. I was government too, but I retired. When I retired in Fort Lauderdale, and I kept my 954 area code, but I'm in South Carolina. I was just there. I just came back from Massachusetts. I was in Canton.
Oh, okay.
About 2 weeks ago, and I went up there in May too. But and I'm planning on going back. But something has got to give. I'm not sure what it is that we need to do. We need to continue to unite voices and keep yelling this out, just like we did with Sandra.
Sure.
Because something has got to give.
Yeah, Agreed.
anywho.
I mean, the defense
Cool.
is doing what they can. I mean, the only thing we can do is continue to try to support Karen Reed because this is very expensive for her. I mean, she can only fight as long as she can pay her attorneys. So the link to support her is in is pinned to the top of the chat. So if anybody wants to support Karen Reed, you can do that.
And I've been buying stuff from like my merch. I get it from Microdots too and the other stuff. So, you know, every time I can, I try to help. They did some standouts here in South Carolina, but I was traveling when they did those in Labor Day. But I'm sure that they're planning on doing another one. So we're going to try to continue to keep it on and keep it alive and help her in every way we can. It's the only thing that we can do. But we need to continue to remain as steady and strong as we are, because everybody can get tired. It can be frustrating. And for some people, you know, some of us are more passionate than others. Mm-hmm. It's like my husband says, I think I lost you to Karen Reed. And I'm going, well, aren't you guys? She's not a male. Because it gets really intense. But, you know, you find ways to tone it down, but then you get reeled back in. So
yeah.
But it was nice talking to you. Thank you for taking the call. I'll try to call later on in a couple of weeks or so.
So Cherry just posted the website for the standouts. So it's in the chat. So.
And the ones in South Carolina are there?
Any organized standout involving these supporters. Yeah.
Look it up. All right, perfect. Well, take care of yourself.
All right, you too. Thanks for calling.
All
right.
Bye-bye. Bye-bye.
Call from.
You're on. Who am I speaking with?
My name's Jason in Alabama.
What's up, Jason in Alabama?
How you doing, brother?
Fantastic.
Excellent. So I have a question for you. I've watched this whole trial. Everybody down here is pulling for Karen Reed, etc. Do you think that Julie Nagel was basically the useful idiot in this whole situation? Because somebody had to put her on that stand. Somebody had to get on that stand and say, oh, I saw a black blob at X amount of time. Because nobody until the actual court date ever placed him on that lawn. You know what I'm saying?
Yeah. I think that she was absolutely, I agree with you. I think that she was absolutely instructed to say that.
Right.
Because the thing is there was nobody on that lawn, and that's why nobody saw him on that lawn. And she can't legally say that she saw a body on that lawn. And she can't say she saw a body on that lawn without explaining why a trained EMT didn't go to help him. So,
right.
So she had to say it was a black blob. I don't know.
Right. Yeah. And it's two parts to that, because somebody during the trial on the McAlbert side had to say, yeah, we saw something on that lawn. We don't know what it was, but we also had to have a whole carload full of people say, I didn't hear. We were talking about peanut butter sandwiches and shit like that, you know?
Right.
Does that make sense?
No, I mean, none of it makes sense.
Right.
Yeah, the whole thing is absolutely insane. But yeah, no, I see what you're saying. Is Julie Nagel? I mean, there had to have been some diversity. They were even bad at that. Is like everybody was prepared to basically say the same shit and respond the same way to certain questions, and they were trying to fake diversity in the testimonies from the people that were inside that house that night, and they failed at that. So,
right. I guess that what stood out to me most about her specific testimony was nobody heard anything about any object being on the lawn until she said it in court, not at some other, not at some meeting, not at some meeting with the police,
not in her grand jury testimony, not in her statement, nothing.
Exactly. Yeah. I mean, that's what stood out to me. I mean, I ain't no Perry Mason shit down here in Alabama, but I mean, we do know how to hide a body, you know?
Well, I mean, it doesn't even take Perry Mason to see that there's something seriously wrong with this case. Like, that's what blows my mind is the people who are just so adamant about Karen Reed being guilty. Like, I'm really seeing a very, very like this really like prominent example of stupidity and ignorance just like blasting me all the time. It's crazy. Like, I'm actually like I've kind of trained myself to find reasons to be grateful for like everything, even things that are frustrating. And it helps
Absolutely.
me.
God is good.
Helps me not be so frustrated. Exactly. Helps me not be so frustrated. Right. There's a blessing in everything. Right. So like I look at that stuff and I'm just like, man, you know, like I've never seen such willful ignorance. And I used to be real quick to just dismiss people as stupid, but they're not. They're not dumb people. They're just ignorant. They just choose to ignore. They're stuck in this echo chamber of Karen Reed is guilty, and they just refuse to pay attention to everything that is contrary to this idea. That is
right. Well, I mean, I'm 100%. I just want justice for John O'Keefe. If you showed me a video tomorrow of her driving a bulldozer and running him over, I'd say throw her in jail. But of everything I've seen, I mean, a blind man's deaf dog could put this shit together. She didn't do it.
I am in the same boat with you, man. Seriously, I was like, for the longest time, even before trial, I was like, let's see. Maybe the prosecution, again, my faith in the justice system. It's like maybe the prosecution has, because I can't imagine why they would go forward with this trial. I can't imagine. So maybe they have a smoking gun, an ace up the sleeve. Maybe they do. You know, I just wanted justice for John O'Keefe. And
that's it.
When I saw this trial, I was like, this is exactly what I was afraid it would be. I wanted them to have the right person. I want justice for John O'Keefe. I didn't want Karen to be guilty. I wanted the right person to be held accountable. That's what I wanted.
Right. Well, I won't tie up your phone line. I just want to talk to you, brother. We watching down here in Alabama, sitting on Lake Martin. I'm about to go out and sit on the pier and catch me some bass.
Right on, man. I love it.
Yes, sir. I might call you again sometime. If the fans ain't making too much fun of my accent, I'll call you again sometime.
Man, don't worry about them, man. I'm in Tennessee, dude. It's all good.
Excellent. All right. Well, come on down to Alabama. We'll drink some beer and catch some fish.
You try to get me fat. Oh, man. All right, man. Have a good one. Thanks for calling.
I love you, bro. Bye.
All right. Bye.
Call from
Debbie.
You're on, Debbie. What's up?
Hey, Clara, how are you?
Fantastic. How are you?
I'm well. I'm actually cracking up sitting on my couch in Massachusetts, little Massachusetts, listening to somebody in Alabama who follows the case. It's just crazy and mind-blowing.
It's great.
But I wanted to just say, I don't know, actually, your thoughts. I was watching, I think, Mike Young Jokes the other night on with Betero, and Mike made a comment that he thinks this case will go back to trial in January. And a lot of people in the chat were like, there's no way.
No, it is.
And I have to agree with them. I was like, we didn't think it would go forward the first time because we know what a sham it was.
I'm with you.
Yes.
I'm with you. I think it's going forward. Now, I mean, I don't know. I don't know. They've appealed to the Supreme Court. So maybe, hopefully.
Yeah.
But I'm with you.
Hopefully.
I mean,
hopefully.
I definitely don't count on Judge Bev to do the right thing at this point.
No, exactly. And you know what? And I hear you say hopefully the Supreme Court, but we've all been hopefully waiting for the feds to come. And I know that they have a fully different job and it takes them a while, but
you got
sitting in Massachusetts and my state taxes are paying for that sham of a trial. And now we're going to come up to another trial.
You've got to take into consideration what just try. I mean, you won't be able to, but try to visualize what a solid case against Michael Morrissey would require as far as an investigation goes, and as far as
I agree
what evidence they need and what type of and how much investigating would require to collect said evidence. So you're looking at Michael Morrissey. You're not just looking at the Massachusetts State Police. You're looking at Michael Morrissey's office, who oversees anything that is prosecuted in Norfolk County. So any case. So you're looking at cases upon cases upon cases upon cases where they're combing through to find misconduct. That's gonna take possibly years.
And then we're also looking at many cases in the Norfolk County that are probably, because of Proctor, going to be thrown out or looked at even closely, like the Walsh case. And it's just a debacle up here. But I appreciate you, and thank you for going over the court documents for the Supreme Court.
Thank you for watching. I appreciate it.
I adore you, and so does my husband. He was laughing at me that I was going to call in because he knows that I adore watching you.
Right on.
All right, have a good night.
All right, bye-bye.
Bye.
Awesome. Great callers today. I'll keep taking calls for like the next 30 minutes.
Call from.
You're on. Who am I speaking with?
Hello, Clara. This is Diane G. I'm in your chat.
What's up, Diane G, in my chat?
I'm from Massachusetts too. I wanted
Get
to
out of
bring
town.
up- of course, yeah. So I wanted to bring up and I know you're not a Facebook person. I get it. It's cool. I hate Facebook too, but I'm on it for a reason. So I'm sure you're aware of this, but other police departments in Massachusetts are actually not as much of a travesty as Canton. Sutton Police Department is the only reason you should be on Facebook. It's just to follow how amazing the Sutton Police Department are, not only on Facebook, but also just in general life.
They don't have a Twitter or an X?
That's a great question. I don't look for them on those, so maybe I should do that. But on Facebook, they are pretty terrific when it comes to like tongue-in-cheek comments about the Karen Reed case and just in general just the corruption. I mean, it's dirty, right? People see it's dirty. That's not a mystery to most people, but obviously there's those people that think there is a conspiracy theory.
Okay, people always ask this. They think I dye my hair. Like, dude, no, I'm old. That's it.
Oh, you look great.
I'm
I don't want
old.
to tell you, but you're a silver fox. You're a silver fox.
I am old, man. That's all. This is all natural. Trust me. I kind of wish that. I mean, I'm just grateful it's all there. You know.
Oh yeah.
So I don't really care what color it is.
Like the Albert.
Right.
I like Chris Albert.
I don't care what color it is, really, as long as it's all there. So I'm content with that. But yeah, my hair is gray naturally. I don't dye it. That's too much time.
Tell him, get it.
Why do you think I cut my hair so short? So I don't have to do anything. It's just, you know.
Oh, imagine if you had like a 60s greaser look though with the silver.
Wow. Yeah, I don't know about all that.
That's a lot of work.
Yeah, what even still, man? You ever see those gray-headed dudes with 50s greasers looks, man? They look like you just got out of prison, you know? Well, because I mean, yeah, they look like they've been in prison since like 1963, you know? Like,
I mean, maybe it doesn't have to be so
mom
perfect,
and
but yeah.
mom and a heart with a fucking arrow through it tattooed on their fucking shoulder, like smoking fucking filterless cigarettes and shit.
Listen, don't ever change. Like you're doing good stuff. You have a lot of followers, so there's a reason you have that. So I don't know. People can say what they want, right?
Yeah, no. People just ask that sometimes. They're just like, "You dye your hair," and I'm like, "No, I don't."
You're not frosting your tips or nothing, though. It's all
no, that's
right?
too much
some
fucking
dimension,
work. I don't even fold my clothes. Like what?
I love my bosses at work, but they use like the hair dye, and it looks ridiculous because like it's thinning and it just looks crazy. So just let it go. Like you got to let it go.
No, I'm good on that. All right, I'm gonna take the next caller. Thanks for calling.
Go for it.
All
Thank
right.
you.
Bye.
Good night. Bye.
Call from.
Hello.
You're on. Who am I speaking with?
Hey, it's Melissa.
Melissa, what's up, Melissa?
How are you? I'm with you on having faith in the justice system, but I've watched the whole trial. Have you?
Yeah.
Have you actually watched the trial?
No. I just
No?
I just streamed it every
Okay.
single day for no reason.
Okay. Well, I mean, I've watched the trial, and believe me, Auntie Bev has been totally biased since day one. And I could not have faith in her afterwards. I mean, I watched and I watched and I watched. And the only thing I liked was that she let Proctor's messages go through where he was just totally an asshole.
Wait a second. Who's this Proctor person? What are you talking about?
Are you serious?
Well, I didn't watch the trial. How would I know?
Well,
I need you to educate me on this, please. Because this is news.
Yeah, okay. Well, you know, we love Trooper Proctor.
Okay.
But anyway, it's just amazing to me that, for one thing, the defense let her get away with this because she is totally biased since day one. And I don't like it. I mean, I don't like it. My husband was a state trooper for years, and I am not from Boston, but I know what good cops are and what bad cops are, and there's some bad cops up there.
Wait, what? In Massachusetts?
No, not
Wait a
in
second.
Massachusetts.
No. Wait.
Massachusetts.
You're talking about bad cops.
Yeah.
Cops don't, there's no such thing. Okay?
You don't think so?
No. Okay?
Why?
Because.
Why?
Because cops aren't bad, okay? And if they arrest somebody, then they arrest somebody, and that's it. You throw them in jail. Why they even have a court system, I don't even understand. It's the strangest thing in the world. Makes no sense to me. Why go through all the rigmarole? Just throw them in jail. You know what I mean?
You're starting to piss me off. You're really starting to piss me off here.
I'm just giving you shit, Melissa.
I know you are. But I mean, it's been just, to me, it's unbelievable. And when I first started, I thought I was the same as you. I wanted justice for John O'Keefe. I mean, truly, you know, before everything started, I thought, yeah, you know, this is bad. I need to hear this trial. I need to hear both sides. I want to know, because somebody's really messing up here, you know? And the whole taillight thing just totally blew me away.
Yeah.
From, you know, I mean, nobody would show her backing into O'Keefe's car or what, you know, what he was driving. And the snowplow driver, just, he and that cop that pulled up in that driveway and said, yeah, she had a cracked taillight. I feel like they're the only ones that were actually telling the truth in this whole freaking thing.
Yeah, I agree
What
with
do
you.
you think? What do you think? I mean, that plow driver to me was A1. He was just amazing.
I agree. Yeah.
Okay.
Lucky Law Firm for sure. Absolutely.
Yeah, Lucky, man. He's the hero. And I can't believe that Auntie Bev didn't take. Well, I mean, the jurors were like, what the fuck? You know? They were like, what do I do with this? She's sending us home. Mistrial.
Totally.
And I mean, I can imagine if I mean, I'm so outspoken that if I was on that jury, I would have jumped up and said, wait a minute. That's just how I am, though. You know, I'm truly outspoken. And nobody did that. Why?
I have no idea.
Would you have said something?
I mean, well, yeah, but the theory is that the one juror that would have said something and spoke up the one juror that would have was dismissed before deliberations even took place.
Okay, juror 3.
Right.
Right? Yeah. Now, why was that juror dismissed?
Don't know.
I don't remember.
I
Okay.
don't know. Something
I don't know
about
if I ever.
something about having dinner somewhere with somebody or taking a video or some shit. I can't remember what it was.
Oh, they were having lunch and he could overhear somebody, wasn't it?
I can't remember.
Yeah, I vaguely remember that now, but it's just a damn shame that, I mean, the whole crime scene was mucked from the start,
Agreed.
It was just a huge mess. And, what do you think about the state police not coming out? I know the weather was horrible, but I mean, that is their job, right?
Yeah. Yeah, you listen to those Las Vegas cops, man, and they're just like, we don't give a shit about the weather, nothing. Like, we're gonna rope off everything. We're gonna rope off the street. And we're gonna be there for sometimes days if it takes that to collect all the evidence.
Well, and my husband was a state cop in a different state, but he was the same. He did investigations. He didn't just do road patrols. He did investigations. And sometimes when my kids were little, I wouldn't see them for days,
Right.
And these guys are like, oh, weather's too bad. Got to go home.
Right. Yeah. It just doesn't add up to it. Doesn't add up to anything factual or fictional about what you hear about how cops do their jobs, dude. Like, it doesn't even add up to any of that.
I watched this and I'm amazed because I guess it's just what I've lived, and it's just what I know from where I am. And it's like, you don't tape off a place until like the next day when there's going to be 12 more inches of snow. You get on it.
Right.
You're on that shit right away.
Right. Like you're on it like double the effort because of the weather, right?
Exactly.
I mean,
let's get down to this.
Read it. Right. We need more resources. We need to do whatever we got to do to preserve this evidence right here. Like, fuck the weather. You don't fucking get a leaf blower and some fucking Solo cups. That's not what you do.
A leaf blower?
Yeah.
Come on.
Don't ask me how I know that because I haven't followed this case at all.
Okay, I'm glad to hear that. But I mean, I've watched every day of the trial, and it's been like an obsession with me, which I don't usually get into this shit, I don't buy into it, and it's like, wait a minute.
Agreed.
Because I'm hearing this turtle boy saying, it's all set up, and I even sent him an email, and I said, I thought you were full of shit at first. I really did. And then I started following the case, and I get it. I'm sorry I had that image of you. And he wrote me back. He thanked me. But here's what I can't understand. How did the McAlberts con so many people into their story? Because there was a lot of young people, there was older people, and they have to live with that every day.
Yeah.
How did they do that?
I don't know.
Do you have any idea?
You'd have to ask a murderer. I don't know. I know. And for him to say that he had a water leak, that's why he replaced the floor, the wall, Oh my God. Yeah.
They so blew it on the investigation. It's unreal to me.
They did.
And for him to be an ex-cop, and he says he didn't know that there were lights, and I mean, how many lights would have been out there?
Exactly.
A lot. You can see that through your blinds. I'm sorry. I wake up when the trash people come to my house. But anyway, I'm venting because I'm frustrated with the whole thing. I don't think it should be where it is right now. I think the whole thing should have been over with.
Well,
and there's a lot of people that think differently, but I don't now. And I was one of the skeptics at first. I was a skeptic. Not really a skeptic, but in the middle, waiting to see. And I don't think she killed the guy. I don't think she backed into the guy. I don't believe it for a minute. And the taillight stuff is all a bunch of BS.
Yeah. I mean, you have those two ARCA experts that I don't know anything about that testified at the trial who say that she didn't back into him. So
I thought they were phenomenal. But what I don't understand is why could they not?
they were
mention
phenomenal, but I wouldn't know that.
But why couldn't they mention that the feds hired them?
You'd have to ask Auntie Bev.
Okay. Well, Annie and Bev and I wouldn't see eye to eye, so that's a nix.
True.
Yeah.
All right. Melissa,
anyway.
thanks for calling. I'm going to take the next caller. Thank you.
Okay, bye.
All right. Bye-bye. You're on. Who am I speaking with?
Call from
Wit Wastewater Solution.
Yeah.
You're on. Who am I speaking with?
Amy.
Who?
Amy.
Hi, Amy.
Hey, I agree with your last caller. I was just wondering why Paul O'Keefe isn't asking himself why Jennifer McCabe didn't say right away that Karen said, I hit him, I hit him, I hit him. Why wasn't that said that morning? Why isn't Carrie Roberts asking herself the same thing? Like, how did that all happen? And I was right there and didn't hear it.
Right. Yeah. I mean, that's, again, that's a drop in the bucket of things that are like, well, why in the fuck did this happen? Or why in the fuck didn't that happen? Yeah, I agree with you.
I also think it would be really cool, and I'm sure all the McAlberts are listening, but if someone weren't to write Carrie Roberts letters from the grave from John, asking her why she's going along with the cool crowd and why isn't she sticking up for him, like kind of like Sean McDonough does with Brian Albert.
Say that one more time.
I think it would get to Carrie if somebody wrote her a letter from John, kind of like from the grave, from John's perspective of why isn't she doing the right thing for him? Why is she going along with the cool crowd?
Yeah, I'm gonna go ahead and recommend to not do that. But I get what you're saying. Don't write letters.
You know what I
to
mean?
Carrie
If she could just hear from John's conscience, you know what I mean?
Sure. Yeah. I get what you're saying. But you mean, that's the thing is what you have to understand is everyone here, this is what's weird about it, is everyone thinks they're the good guy and everyone thinks that they're doing everything in the interest of fighting for the little guy. Everybody thinks they're doing that. They will do selfish things and then they will convince themselves that they're not. That's what's going on here is you have these blue shirt people who are convinced that their hatred for Turtle Boy, they've convinced themselves that their hatred for Turtle Boy is actually not a hatred for Turtle Boy, but a pursuit of justice for John O'Keefe, which is just not true. Because if they were actually pursuing justice for John O'Keefe, well, then they would actually pay attention to indisputable evidence. And they're ignoring all of it. So that's how people think. I mean, no matter what, so Carrie Roberts is thinking that she's doing everything that she can to get justice for John O'Keefe. And, Paul O'Keefe is even doing that right now, is saying, he's convinced himself that, this is the best thing to get justice for my brother. And he loves his brother. And I'm not doubting that he loves his brother. I'm saying that he is going one route and convincing himself that the reason why he's going that route is in the interest of of justice, when it is not. Because they constantly tell you Turtle Boy, 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 Turtle Boy. And then you're like, okay, well, are you if you're ignoring all of the facts that indicate that Karen Reed is innocent, and you're trying to just it's telling me that you're just trying to throw someone in jail because you didn't like the person who provided you with the information that they've got the wrong person.
Right. The psychology behind the way that these people are acting is very interesting. If you take Julie Nagel, for instance, I can't stand her, but I do have to give her credit because I feel like she's been manipulated. She was in the house when John died, and she didn't hear anything. And I think it's something where Jim McCabe is going, you were even in the house. No one died. And she's like, duh, I was even there. And so she's fighting so hard because she can't fathom it, that it really happened. And so it's not everybody's hiding the conspiracy. It's that some people who are involved they don't even realize they're covering it up.
I mean,
So
yeah, that's
anyway, thanks for having me on. Thanks for the conversation.
no problem. Thanks for calling. I appreciate you.
Yep. Bye-bye.
All right. Bye-bye.
Call from
You're on. Who am I speaking with?
Blair, I wanted to hear you talk about me today, so I know that you really do care.
Okay. Who am I talking with?
It's Reality Check.
Oh, hey, what's up, Reality Check?
Not much. So I was listening to Mark and Melanie earlier, and they really brought up some good points, especially with the issues that they had this, 20 some odd day or 2-month trial. The juror sat there for how many monotonous days listening to lollygag, and the defense only took 6 days. But for her to turn around, for Auntie Bev to turn around and not even let them discuss the amount of time that they would have for closing arguments, and the fact that you've got trials that have gone on for months like that, like Donald Trump's, other ones, they're given, it's max of like 5 hours, but for a case of that magnitude to only be given an hour, and they had so much information to condense in, they couldn't literally go through their follow-up and go through those jury instructions with.
That was clearly another example of Auntie Bev coddling Lally, because the thing is Lally didn't have a case. So it would actually, for him to actually fill up an hour's worth of closing arguments for the weak case that he had was already a stretch, right?
Mm-hmm.
But for all of the exculpatory evidence for the defense to go through would take minimum 2. You know what I mean?
Yeah, and especially with the fact that with Mass not allowing them any readback. So here you are trying to get all your information in because she's not allowing readbacks, and you're not even allowed enough time to get the main points in there.
Right.
That's very prejudicial.
Oh, yeah. Everything was prejudicial. And everything she did was prejudicial. Again, that's why I say she's corrupt. I mean, I'm not saying just because if I say somebody's corrupt, it doesn't necessarily mean that I think that they're taking money from somebody or that sort of thing. I just mean that their position has been corrupted. What their job entitled them to, what their job tasks them to do. If they don't meet that task, then they are by definition corrupted.
Mm-hmm.
She is tasked with making decisions in the interest of justice. She hasn't done that, so she is corrupt.
I think that her and Morrissey were twins separated at birth. I really do.
Well, I'm pretty sure they're friends. So.
Oh yeah, everybody down there seems to be friends,
right?
In one way or another. Now that's just the main points that I was picking up on it, and I'm praying that they schedule this quickly, and I'm praying they don't bump it, up to another level and then bump it back down to Bev and say, because this is just gonna drag on forever. And the sheer fact that they did bring out the fact about how much money this is costing Karen, that was a huge, awesome bring out in that, because that is very prejudicial, and they're trying to bankrupt her.
Yeah, that's because they're using civil court tactics, which is really weird. Like the prosecution is using civil court tactics, which is classic. It's they will wear you down. They will wear you down until you're just bankrupt, until you are financially drained and you can't afford the resources to fight the fight anymore. So
yep, and then you'll get a public defender.
Right. That's what they're basically trying to do. And who does the public defender work for? The public defender gets the same signature on their paycheck as Adam Lally. So, I mean, that's, normally I'd be like, okay, in the interest of having faith in our justice system, sure, great, public defender's fine. But not in Canton, not in Norfolk County. I don't trust that shit for 1 second.
Me neither. And just for your caller, that I actually am in South Carolina, and we've been the ones that have been doing them down here. We do have a group on Facebook. I believe it's Coastal Carolina for Free Karen Reed. It's a public group. She can join there, and that's when we discuss where we're going to have them, because we want to try to accommodate everybody, but we know that not everybody lives close together. So she can also get in there and get her input in, and we'd love to have her.
Right on. Awesome. Is it listed?
All right, well, I'll let you get your next one.
Is it listed on the website for all of the standouts?
When we schedule one, yes, I do give the information to Paul, and he does put it on.
All right, cool. Awesome.
All right.
Thanks
have
for
a great
calling.
Day, Claire.
Thank you. Bye-bye.
Bye.
Okay. Phone lines are now closed. I was trying to get kind of an impromptu guest to join me. I don't think that's going to happen because it's kind of short notice. I was trying to make that happen, and they responded while I was live, but I didn't check to see if they were going to respond, and they could have responded. I don't even know what time it was that they responded, and so it didn't happen. So maybe next time. I'm going to leave it a surprise because I still want it to happen. Just it's not going to happen on this live stream. But anyways, guys, maybe I'll do a late night live tonight. I don't know. We'll see, because there's other stuff I really want to discuss. There's some other stuff I really, really want to discuss. But anyways, guys, I am going to wrap this up. Thank you guys for all your support. Thank you guys for liking the video. Thank you guys for subscribing. All of you who have, I really appreciate you guys. You guys are absolutely fantastic. Great callers again, as usual. Make sure to go over, check out the great Mark Betterow on the Young Jerks. I believe they just went live. If not, they're about to. Anyways, guys, I love you guys very much. You guys are fantastic. And we will do this again very soon, my friends.